McCluskey vs. Kemp. Warren McCluskey was sentenced to death for killing a white cop. The trial took place on April 22, 1987, in the Georgia Supreme Court. Kemp is the superintendent of the Georgia Diagnostic Classification Center, which is also known as a prison. The facts about the case: McCluskey, who is an African American, along with 3 other accomplices, charged with 2 counts of armed robbery with a furniture store and 1 count of murder. The victim was Atlanta police officer Frank Schlatt, who happened to be white. Schlatt was shot in the face by the burglar that was hiding under the couch in the furniture store. The weapon Schlatt was shot with was a shotgun. Frank was 30 years old and had been on tour for 5 years. He died on 5/13/78. The jury found that 2 aggravation circumstances existed beyond reasonable doubt. The murder was committed during the course of the armed robbery, and the murder was committed upon the police officer engaged in the performance of his duties. A finding of either circumstance was sufficient to impose the death penalty upon Warren McCluskey. The court followed the jury's recommendation and sentenced petitioner to death. McCluskey then tried suing Kemp for racism. McCluskey claimed the following arguments. The Baldus study demonstrated discriminatory intent by Georgia in the imposition of its death penalty statute in violation of the 14th Amendment's Equal Protection Clause. McCluskey claimed his sentence was disproportionate to similarly situated defendants, and the level of the jury's sentencing discretion allowed racial prejudices to improperly affect its decisions. Racism played a big role in this case. The Baldus study was David C. Baldus, and he's a professor of law in the University of Iowa. He claimed a person who was accused and convicted of killing a white victim was 4.3 times more likely to get death penalty than killing a black victim. A black defendant is 1.1 times more likely to receive death penalty with a white defendant. The Baldus study demonstrates a clear pattern of differential treatment in imposing the death penalty on the basis of race. McCluskey was sentenced to death with a 5-4 ruling. The ruling was claimed unconstitutional under the 8th and 14th Amendment. The 8th Amendment is cruel and unusual punishment, and the 14th Amendment is equal protection under the law. McCluskey was then executed on September 25, 1991. This case relates back to Dred Scott v. Sanford. The decision was that African Americans, slave or free, are not U.S. citizens and therefore cannot sue in a federal court. Sanford was Scott's owner. However, Scott tried suing Sanford in a federal court. The ruling was 7-2, not in Scott's favor. The public reaction. The decision in the case provoked outrage in the civil rights community and launched a multi-year campaign to seek redress in Congress. The House of Representatives twice passed legislation known as the Racial Justice Act, which would have provided a federal remedy for racially identifiable pattern of sentencing that can only be explained by discrimination. The decision came within 10 votes within the Senate, but was stopped repeatedly by a bipartisan bloc of Southern senators. The Southern senators insisted that a federal non-discrimination standard would mean the end of the death penalty within their states.